Hello friends, today we'll discuss about indemnity contracts. In the previous class we have seen quasi contracts, contingent contracts, all the tough topics, but it is quite easy if you understand. So tough topics are going on. Indemnity contract, many people will be scared by the word indemnity. So nothing to worry. Indemnity contracts also very important contracts. What is this indemnity? Indemnity means making a loss good. If any loss is going to come, one party is saying, don't worry, I'll take care of this loss. I'll make this loss as good. Means loss is converting into normal way. No loss at all. Means indemnifying the loss. Means compensating the loss. I'll give you much clarity. Suppose say A is purchasing goods from B. A is purchasing goods from B. Then in such case, say C is giving indemnity, or C is saying to B, don't worry, let A to purchase the goods on credit basis, not cash basis. Let him buy, but I'll take care if he doesn't pay the amount. If A is not going to pay the amount, A is purchaser na? Purchaser and owner, shop owner. If A is not going to pay the amount, then I will pay. I will pay. So means loss is going to bear by C. This is, we call it as the indemnity contract. Indemnity contract. Now here we call him as a C as indemnifier. Means the person who is giving assurance, indemnifier. And the person who is purchasing goods, he'll be called as indemnity holder or indemnified. Indemnity holder or indemnified, anything we can say. Now right now the contract is between A and C only. There is no contract with owner, A and C. If A is not going to pay, C is going to take care of the amount. C is going to make the payment. So this is indemnity contract. Now if a contract has to be indemnity contract, what should be the features? What kind of things are to be fulfilled? That features we are discussing right now. The first one is the parties. For indemnity contract, how many parties are required? 2 parties. As we have discussed, 2 parties. That is purchaser and a person who is giving the assurance. So 2 parties. First party is here indemnifier, who is giving the assurance. And another party is indemnity holder. So that is what I have written here. Indemnifier, indemnity holder and indemnified. Anything you can say, but first party is indemnifier, who is giving the assurance. Second party is indemnity holder or indemnified. So anything. So 2 parties will be there, the parties. 2 parties. Second one is consideration. Strictly speaking, in indemnity contract there is no consideration at all. When C is ready to give the assurance, is C is going to get any kind of consideration? Is he going to get any benefit? No, not at all. But as per the court of law, whatever assurance is giving by C, that itself is consideration, we say. Anyway, C will be the loser automatically by giving surety if A is not going to pay. So that is why consideration is not there in the indemnity contracts. The third one is conduct of the promisor. Now if at all A is not going to pay the amount, if A is not going to pay the amount, then who has to pay? Conduct of the promisor? C. C has to pay the amount. Unless something is decided that some other party is going to make the amount, like C is saying, my son D will take care, then it's okay. If not, nothing is mentioned. Third party cannot enter into the contract. Third party cannot pay the amount. So that is what saying conduct of the promisor. Only the indemnifier has to pay the amount, or otherwise as specified by the indemnifier, D or somebody also can come, but it should be in a proper way. And next one, expressed or implied. This contract, indemnity contracts can be expressed or implied. Expressed or implied we have already discussed in the types of contract. Hope you remember types of contract. Please go back, you will get very clarity. In types of contract we have discussed expressed contract. Expressed contract means when a agreement is made between promisor and promisee, either in words or written, that is expressed. Oral or written, that is expressed contract. Or implied, implied means no written, no oral, only gestures. Through the gestures, through the actions, if he is saying something, then that will become implied. Anyway, this indemnity contract can be expressed or implied, anything it can be. Through a gesture also, suppose say A is purchasing goods from B, C is just giving gesture, don't worry, I'll take it, not speaking anything, just a small gesture, that will also become indemnity contract. That is what we are saying, expressed, it can be expressed or implied. Next, other features. As per the Indian contract law, we have discussed some features. What is needed for contract? Promisor, promissory, promisee, and also there should be some consideration. Anyway, consideration is not there, only this point is not there, and capacity of the parties. I mean, they should be major and must not be a lunatic or drunkard. So, sound capacity. So, that party, and also it should be like a legally approved contract. So, that kind of all facilities, all the features has to be fulfilled in this indemnity contract. Apart from this, last one is insurance contracts. Insurance contracts are specially for those contracts, marine contract or road accident contract or theft or any kind of life insurance. All these contracts comes under the insurance contracts. Insurance contracts are not indemnity contracts. Insurance contracts are not called as an indemnity contract, because insurance contracts, what happens when insurance is taken by the promisor and promisee, anyone. So, insurance is taken, yearly some premium amount they will be paying, some amount they will pay, and they will be getting some consideration also, some amount they will be getting, premium policy amount they will be getting. So, that itself is a consideration. When there is a consideration in this insurance policies, that will not become indemnity contract. That is why insurance contracts are not indemnity contracts. Are you getting it? Because premium paid and also some amount is receiving, that consideration is there. That is the reason we do not consider it as a indemnity contract. These are the main features of indemnity contract. Am I clear? Let me give you a repetition. So, indemnity contract means when any loss is there, that loss is going to indemnify, means going to bear, going to compensate by another person. So, that is giving surety. So, that is called as indemnity contract. What are the features? Two parties. First one, who are the indemnifier? Indemnity holder, two parties will be there. Consideration will not be there. Next, conduct of the conduct of the promisor. Only a person who promised to bear the loss, only he has to bear it, or decided as per the all the parties. And next one, it can be expressed or implied. Other features, all the other features of contract must fulfill except consideration. Next, insurance contracts are, we won't consider it as a indemnity contract. That's all. This is about indemnity contract. In the next class, we'll discuss about guarantee contracts. Many people will get confused with this indemnity contract and guarantee contract. You will have a very good clear idea. Just stay tuned with my channel and do share these videos with many students who are struggling to learn the subject. So, immediately you open the textbook and read this topic, note down the synopsis. Till the exams time, you will be able to remember this topic. So, thank you very much for all your feedback. Stay connected with me. So, shortly I am going to come with other topics. Wish you good luck. Take care.